Hello friends, from now onwards we are going to discuss article wise the fundamental rights. In this video we'll discuss two articles, Article 12 and Article 13. What Article 12 says and what Article 13 says. They are creating a base for the further articles or fundamental rights. Many times we have used or number of times we are going to use the word state. In this article they have described what state is. So they say that state includes government, Parliament of India, and the government and the legislature of each state, and all local bodies, other authorities within the territory of India under the control of government of India. So under the control of government of India, so it includes all legislature, parliament, in parliament, executive, legislature, in state governments, government of states, state legislatures, and in all local authorities, panchayati raj arrangement, panchayati raj arrangement, municipal bodies, panchayats. So they all are considered states. And you heard about the public sectors such as ONGC and other bodies. So they are come under as a state. They are of two types, statutory and non-statutory. Non-statutory. So one body is may formed according to the law of the parliament, another is not mentioned into the Indian Constitution. And even because after a point in public administration, author says that there is a need to roll back of the state when rollback of state means when state reduced to regulatory framework only and all the services are provided by the private sectors. So private sectors are taking care of education, health, banking sectors, agriculture sectors. If private sector are taking care, then these sectors can be equivalent to state. So Supreme Court enlarged the state definition. They saying that state include those entity also which are fulfilling or working within the meaning of state. So they can be considered as a state also. So Article 12 says about the state definition. This Article 13 talks about the laws in a territory immediately before the commencement of this constitution. If any law which is formed before the 26th Jan 1950, and if these laws are inconsistent with the fundamental rights, then they are null and void. They are illegal, means they don't have any place or say in our constitution. And what the state means, state is, we have discussed the state in the article 12. In this we are saying that state shall not make any law which take away the law which take away the fundamental rights. It means if such laws are made, then those laws are void. And it says that what are laws? Laws include any kind of ordinance order, bylaw, rules, regulation, notification, customs, usage, or in the territory of India of the, so any law, rules, regulation is formed and which is against the fundamental rights, then they are also null and void. For example, recently we are hearing in the news that college or some organization banned the wearing of jeans and carrying of mobile by the girls. Though the moment they say it is obviously unconstitutional, and because these bodies don't have any existence in terms of they are unorganized, and these bodies are not registered, and even if they are registered, then these laws are unconstitutional, and they easily we can go to the court to get these bodies to be fined or to come to take them to the court. So how we can go to the court? We can go to the Supreme Court under the Constitutional Remedies Act under Article 32, and we can approach to a High Court under Article 226. So, and there is a case that people were saying that Article Constitutional Amendment Act cannot be considered as a law because they are saying that Constitutional Amendment Act, if suppose these are number of article, if we can amended the article and we form another, then how can it be a law? It is the constitution itself, they are saying. But Supreme Court says that Constitutional Amendment Act can also be challenged on the ground that it violates the fundamental rights, which is the basic structure. So if any constitutional amendment act, if suppose we did a constitutional amendment act, it says that nobody is allowed to express his expression and views, and they remove the 19 part 1 of Indian Constitution, the Constitutional Amendment Act. That is the basic structure or the basic spirit of Indian Constitution, and if that is taken away, then it means that that Constitutional Amendment Act is illegal or the void law because it is acting as a bridge to achieve to realize the fundamental rights. So in that case, this law is void. So see you in the next lecture. Thank you so much for watching.